In the case of Jason and the Blue Shoe Company Limited, who appears?
Good afternoon, my lord. My name is Rory Gilchrist and I appear today as senior appellant with my learned colleague Miss Kelsey Laird appearing as junior appellant. My learned friends across the bar are Miss Scarlett Wilson appearing as junior respondent and Miss Louise Kelly as senior respondent. It is submitted to the court on behalf of the appellants that there are two grounds of appeal as outlined in the skeleton argument provided. The first being that the Court of First Instance erred in refusing the action as there was in fact an existing duty of care in accordance with Lord Aitken's judgment in Donoghue against Stevenson. Secondly, the appellant submits that the risk of injury was foreseeable, therefore the damages sought are not too remote. I will be addressing the first point of the appeal regarding Donoghue against Stevenson and the neighbourhood doctrine, while my learned senior, Miss Laird, will be covering the second point of the appeal. If it pleases your lordship, I shall begin my submission.
Please do.
Would your lordship care for a summary of the present case before the court?
A very, very brief summary, please.
Of course, my lord. The appellant was gifted by his girlfriend a pair of Blue Eagle trainers manufactured by the respondent. The Blue Shop Company Limited. The appellant's girlfriend made the purchase at Sneaker Stop, a third party. The appellant wore the shoes at the Crazy Night Bar later that evening, where the shoe's metal wire ripped out of the frame and pierced his foot, which resulted in his left foot being badly infected. As a result of this piercing, the appellant was informed by his doctor that he had contracted sepsis and was required to take 4 weeks off work due to his injury. Since the Blue Eagle trainers were launched, a further 5 individuals have been injured while wearing them. My lord, my first ground of submission will be in regard to the duty of care established by Lord Aitken in Donoghue against Stevenson. If I may direct your lordship to the binding case of Donoghue against Stevenson, heard in the House of Lords in 1932, reported in UK House of Lords, which is located in tab 1, page 4 of the bundle provided. Does my lord have sight?
I do. Before you take me to the facts of that case, you said that case is binding on us today, but I see it's a Scottish case, and this is an English court. How is it binding on us?
Thank you, my lord. The case is binding on the court appearing before us as it was held in the House of Lords, which is the Supreme Court of the United Kingdom.
Thank
you. Would your lordship care for a synopsis of the Donoghue against Stevenson case?
Very brief.
Of course, my lord. The events of the case took place in Paisley, Scotland in 1928. While attending a store, Miss May Donoghue was given a bottle of ginger beer purchased for her by a friend. The bottle was later discovered to contain a decomposing snail. Since the bottle was not made of clear glass, Donoghue consumed most of its contents before she became aware that it contained a snail. She later fell ill and the physician diagnosed her with gastroenteritis. If I could now refer your lordship to the dictum of Lord Aitken at tab 1, where he rules, "Whom then in law is my neighbour?" The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in my contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. My lord, I submit Lord Aitken's doctrine applies directly in the present case before this court. In Donoghue, the appellant did not purchase the bottle of ginger beer, but was rather gifted it from her friend, who did not purchase it directly from the respondent, but instead a third party. Despite this, Lord Aitken held that the respondent held a duty of care to the appellant through the neighbourhood principle. It is submitted, your lordship, that this applies directly in the present case. The respondent held a duty of care to the appellant, and this duty was broken by the appellant's injury. It is for these reasons, my lord, and those submitted by my learned junior, that the appellant submit that the appeal should be allowed. Thank you, my lord. If there are no further questions, that concludes my submission.
Just one question on Donoghue and Stevenson. Was it a unanimous judgment of the House of Lords?
It was not unanimous, my lord, no. But it was by majority.
Okay. Thank you.
As previously introduced by my learned senior, my name is Miss Kelsey Laird. Today I stand before you as junior counsel for the appellant, Jason. If I could direct your lordship to page 1 of the digital bundle, you will find the skeleton argument for the appellants. As it has been previously submitted, the appellants owed a duty of care to the respondent in accordance with the neighbourhood principle. If it pleases your lordship, I will proceed to submit ground B of the appeal that the damages sought are not too remote. My lord, this is submitted by distinguishing the application by the respondents of Bolton and Stone, which was heard in the House of Lords in 1951 and reported in the appeal cases beginning at page 850. This can be found at tab 2 of the digital bundle, which is page 6. Would your lordship care to be acquainted with the facts of the case?
A very brief synopsis would be welcome.
Of course, my lord. Miss Stone was injured when she was struck by a cricket ball outside her home. She brought an action against the cricket club in negligence. The cricket field was surrounded by a fence 17 feet above the cricket pitch. The cricket ground had been there for 90 years without injury, and it was held that there was no breach of duty since the likelihood of harm was low, that the defendant had taken all practical precautions in the circumstances. It is submitted to your lordship that in the case at hand, that the damages were foreseeable. If I could direct your lordship to page 7 of the digital bundle, highlighted you will find the judgment of Lord Oaksey. He states that cricket has been played for about 90 years on the ground in question, and no ball has been proved to have struck anyone on the highway near the grounds until the respondent was struck, nor has there been any complaint to the appellants. My lord, although Judge Oopsey rejected Jason's action on the basis that the incident was so remote that a reasonable person would not have anticipated it, when examining the case, the facts are distinct enough to separate the judgments. My lord, the decision in Bolton and Stone was held based on the exceptionality of such damage. As it can be seen from the facts of the current case, the damage suffered by Jason is not one which was exceptional, having occurred 5 times since 2017. My lord, the relevance of this judgment is to demonstrate that the previous occurrence of harm grants foreseeability. It is submitted that due to the occurrence of previous cases of injury to the wearers of Blue Eagle trainers, the manufacturers can be held to possess a duty of care to Jason, as they have failed to take reasonable care in the manufacture of the shoes to prevent damage which can be considered reasonable. If it pleases your lordship, I will proceed to conclude the appellant's submission to allow the appeal.
But before you do that, can you please advise me, is the case of Bolton, is it binding on the court today?
Yes, my lord, it is binding. It was heard in the House of Lords in the English court.
Thank you.
It has been submitted, my lord, that based on the reasoning and authority provided, that firstly, the respondent did owe a duty of care to the appellant, as it was established under the neighbourhood principle. Secondly, it was submitted that the injury caused by the breach was not too remote to be guarded against, and that liability should be imposed. If my lord has no further questions, that concludes the appellant's submission.
Just one final question. Can you explain the concept of duty of care, please?
Yes, of course, my lord. So, duty of care is imposed upon persons, individuals, companies that have an expectation or responsibility placed on them where their actions could directly affect an individual or an individual's property, and that in those circumstances they have a duty to take all reasonable care to avoid injury or damage to those property or individuals.
Thank you.
Thank you.
Good afternoon, my lord. If it pleases your lordship, my name is Louise Kelly, and I appear today as senior counsel for the respondent. I appear alongside my learned junior, Scarlett Wilson. I shall be dealing with the first ground of the reclaiming motion, specifically that the risk of serious injury to anyone buying the shoes is so remote that a reasonable person would not have anticipated it. My lord, the question before the court this afternoon is, does the Blue Shoe Company owe Jason a duty of care? The respondent submits to your lordship that the respondent does not owe a duty of care because the risk of injury was too remote. With your lordship's permission, I will support my submission by establishing that the risk of injury was too remote, I will do this by proving that a reasonable person would not have expected such a serious injury to occur from the shoes, and thus a duty of care shall not be owed to the appellant. My lord, it is fair to say that the risk of severe injury from shoes is so remote that a reasonable person would not have expected it.
Can you pause for a second? Can you just explain to me that this reference to reasonable person? What is a reasonable person? Who is a reasonable person?
A reasonable person is someone who would act in the course of reasonable duties, and something that a reasonable person would not expect to be out of the ordinary.
Thank you.
The respondent acknowledges that 5 people had been injured whilst wearing the shoes. However, the respondent emphasises that nor the severity of the injury or the cause of the injury is specified. Therefore, it can be argued that the seriousness and cause of the injury is exceptional, and that a reasonable person would not have expected it. This means that no duty of care was owed to the appellant, as the respondents were not obliged to guard against such remote risk. My lord, I now wish to cite the authority of the case of Bolton against Stone. This is in, if I may direct your lordship's attention to page 4 of the digital bundle.
I have sight.
My learned friend across the bar, Kelsey, has provided a brief summary of the facts of the case, so I expect your lordship will not require.
Please proceed to your submission.
If it pleases your lordship, I will read from this case in the judgment of Lord Oaksey. Many foreseeable risks are extremely unlikely to happen and cannot be guarded against except by almost complete isolation. The ordinary prudent owner of a dog does not keep his dog always on a lead on a country highway for fear that it may cause injury to a passing motorcyclist, nor does the ordinary prudent pedestrian avoid the use of the highway for fear of skidding motor cars. These situations are comparable to the respondents. The respondent does not have to stop selling shoes for fear of the shoes injuring someone. The respondent is only obliged to take precautions against risks which are reasonably likely to happen. If this risk was reasonably likely to happen, the respondent would stop production and sale of the shoes. However, in this case, the risk of injury was too remote, and it would be unreasonable to expect the respondent to carry out such extreme measures. In conclusion, my lord, I have submitted what I believe to have proven that it would be unreasonable for the respondent to guard against such a remote risk. The injury was too remote for the respondent to guard against, and the extent of the injury suffered were exceptional. Therefore, I submit that the respondent can be held in no way accountable for the appellant's injury, and that the respondent does not owe the appellant a duty of care. If your lordship has no further questions, that shall conclude my submission.
Just one question. The case of Bolton, is that binding on the court today?
Yes, my lord, it is binding. It was held in the House of Lords.
Okay, thank you.
Thank you, my lord.
Good afternoon, my lord. If it pleases your lordship, my name is Scarlett Wilson and I am here today as Junior Counsel for the respondents, Blue Shoe Company Limited. I appear along my learned senior, Louise Kelly. I shall be dealing with ground 2 of the reclaiming motion. This is found at the first page of the digital bundle. Specifically, that Jason did not act as a reasonable person would have done, and the infection of Jason's foot was not caused by the shoe breaking. My lord, the question before the court this afternoon is, are Blue Shoe Company Limited accountable for Jason's contraction of sepsis? I submit to your lordship that Blue Shoe Company are not accountable, as there is a break in the chain of causation. I further submit to your lordship that Jason did not take reasonable care to prevent his infection. With your lordship's permission, I will support my submission by establishing what a reasonable person may have done in Jason's situation. I'll then compare these actions to what Jason actually did and prove that there was, in fact, a break in the chain of causation. My lord, it is fair to say that a reasonable person would have removed their footwear upon arriving home. They would have then cleaned the gash on their foot in order to prevent infection. This is not what Jason did.
Ms Wilson, before you proceed, could you just explain to the court what you understand by chain of causation?
So a chain of causation is that the end act, the end result, in this case Jason's contraction of sepsis, was caused by the respondent, in this case Blue Shoe Company Limited, and the fact that the shoe broke. The respondents accept that the shoe did break. However, we say that Jason should have acted upon the wound on his foot and therefore prevented his infection. The respondents therefore did not cause the contraction of sepsis.
Okay, thank you.
Jason did not notice the wound until the next morning, when it had already become infected. This infection was not foreseeable in any way by the Blue Shoe Company, and it is fair to expect persons to notice and care for a minor injury. My lord, I now wish to cite the case of McHugh and Holland and Hannon and Covitz Limited. This established how a break in a chain of causation for personal injury should be treated. It was reported in 1969, Volume 3 of the All England Law Reports, page 1621. This is at page 6 of the digital bundle.
I have sight.
Thank you, my lord. Does your lordship require a brief summary of the facts of this case?
A very brief.
The appellant in this case sustained injuries to the leg for which the respondents were liable. However, the appellant sustained another injury to the leg by not acting with due care in regard to the injured leg. The respondent was held not responsible for this collateral injury. If it pleases your lordship, I will now read from Lord Reed's assenting opinion, which is highlighted at page 7. But if the injured man acts unreasonably, he cannot hold the defender liable for injury caused by his own unreasonable conduct. This situation is directly comparable to Jason's. Jason did not care for his foot and hence did not act reasonably. It is fair for a business to expect that a consumer will probably care for any minor injuries. To conclude, my lord, my learned senior has submitted that the risk of injury is too remote on the ground of Bolton and Stone. If this first ground is rejected by the court, we submit that there is no chain of causation. I've submitted what I believe a reasonable person would have done in Jason's situation. The infection was in no way foreseeable to Blue Shoe Company Limited, as they may expect any person to clean and care for a personal injury. Therefore, I submit that the respondent can be held in no way accountable for Jason's infection. If the court has no further questions, I will conclude my submission.
Thank you. I have no further questions. Thank you for your submissions. The court shall now retire to consider its verdict in this case.
Your Honour, my name is Rory and I appear today as senior appellant with my learned colleague Kelsey appearing as junior, and across over there is Scarlett appearing as the junior respondent and Louise as senior respondent. It is submitted today that on behalf of our side there are 2 grounds of appeal as outlined in the document we sent. The first being the court which this case appeared beforehand was wrong to refuse action because there was duty of care, if I said that right, yeah. And this was shown by Lord Aitken in Stevenson and Donoghue. The appellant also submits that injury was seen because damages are not remote. Kelsey will be covering the second point and I'll be covering the first point. If it pleases my lordship, I will start my argument.
I think you can stop there. Thank you.
Good afternoon, my lordship. If it pleases your lordship, my name is Scarlett Wilson, and I appear today as junior counsel for the Respondent's Blue Shoe Company. I appear alongside my learned senior, Louise Kelly. I shall be dealing with ground 2 of the reclaiming motion, specifically that Jason did not act as a reasonable person would have done, and the infection of Jason's foot was not caused by the shoe breaking. My lord, the question before the court today is, are Blue Shoe Company Limited accountable for Jason's contraction of sepsis? I submit to my lordship that Blue Shoe Company are not accountable as there is a break in the chain of causation. I further submit to your lordship that Jason did not take reasonable care to prevent...
Miss Wilson, if I can interrupt, can you explain what is meant by the concept of chain of causation?
Well, my lordship, no, I cannot. My learned senior will deal with that. With your lordship's permission, I will submit that by establishing what a reasonable person may have done in Jason's situation, I'll then compare these actions to what Jason actually did and prove that there was a break in the chain of causation. My lord, it's fair to say that a reasonable person would have removed their footwear upon arriving home. This person would have then cleaned the gash on their foot in order to prevent infection. This is not what Jason did. Jason did not notice the wound until the next morning, when it had already become infected. This infection was not foreseeable by Blue Shoe Company, as it was fair to expect persons to notice and care for minor injury. My lady, I now wish to cite the case of McEwen, Holland and Hannon and Cupboards Limited. This case is established. By breaking the chain of causation, personal injury should be treated.
Miss Wilson, is the case of McEwen, is it binding on the court today?
I don't know, my lord. Does your lordship have sight?
I don't.
It's page 6 of the bundle.
And can you give me a brief summary of the facts?
Yes, there was an injury and the respondents weren't liable because the appellants did not take due care of the injury. I can read from Lord Reed's assenting opinion. But if the injured man acts unreasonably, he cannot hold the defender liable for injury caused by his own unreasonable conduct. This situation is directly comparable to Jason's. Jason did not take care of his foot and hence did not act reasonably. It's fair for a business to expect that a consumer will properly take care for any minor injuries. In conclusion, my lady, my learned senior has submitted that the risk of injury was too remote on the authority of Bolton. If the first ground is rejected by the court, then we submit that there is no chain of causation. I've submitted what I believe a reasonable person would have done in Jason's situation. The infection was in no way foreseeable to the Blue Shoe Company, as they may expect any person to clean and care for a personal injury. Therefore, I submit that the respondent can be held in no way accountable for Jason's infection. Ms Wilson, you referred to due care. Can you explain what you mean by due care, and what is due care on the part of a reasonable mooter? The respondents were not liable because Jason didn't clean his foot. In this situation, due care would have been Jason cleaning his foot.
And on the part of a reasonable mooter?
On mooter, it's reading a good speech.
Thank you.
So today we have heard a full mock moot from our 4 student instructors involved in the African Schools Mooting project. The first moot that you saw was an exemplary example of best practice, how to do a moot in a clearly audible, well presented and well reasoned way. And then after that we had a little bit of fun when Scarlett and Rory provided examples of some mooting that they have experienced once or twice, which does not live up to the best standards of mooting. So before I go to give my judgment in this case, I want to identify and refer to some of the examples of the things that Scarlett and Rory did, which you should try and avoid when you come to do your mooting, both in the practice moot in January and also in the mooting competition proper next April 2022. So obviously there are many things that everybody will be able to quickly identify that were incorrect or not appropriate. Mooting and arguing a case in court, they're both very formal and small c conservative undertakings. There are many rules, as you've heard over the course of this of the training, that must be followed, many things that must be avoided. First of those that I'll mention is the way in which you address the judge who is judging the moot. You've heard some examples in the first proper moot that were entirely correct. You refer to the judge as my lord, my lady, your lordship, your ladyship. You do not refer to the judge as just judge or get the gender of the judge incorrect or refer to the judge as your honour, that's wrong. When mooting, or indeed when arguing a case in court, the most important thing is to make sure that the audience, the jury or the judge or the person, the people judging the moot, they clearly understand and are able to access all of your points. To do that, you must speak at an appropriate pace. You must not go too quickly, and you also must make sure that you make very good eye contact. So we saw when we had Scarlett's second attempt that she had her notes almost hiding her face. And also Scarlett, she successfully managed to speak incredibly quickly. So it was almost impossible to follow what she was saying. But we had heard it all before. Also, she was rather informal and jocular in the way in which she behaved. She did not have sufficient gravity. And that was exhibited even more clearly by Mr. Informal himself, Rory, who really seemed as if he came straight from the pub or nightclub to argue before the court. He was just far too informal. He had incorrect titles. He referred to our side. He referred to people by their first names. That is not what you should be doing. His terminology was incorrect. He referred to the first court, in this case, being wrong. That's not what you would submit. His pace was not too bad, but really he did not have the requisite level of gravity and seriousness that we would expect in a serious mooter. So by seeing the contrast between the first example, which was excellent, which is the type of practice you should aspire to adopt yourselves, and the second examples, you can see what is good and what should be avoided. So I hope that you find what we've done today in this video to be helpful. You should look at it several times to pick out all the good things that you see, the way in which the mooters answered the questions. It may be possible to predict some questions that I might ask. Others might take you unawares. And you can see that all of our mooters today, when they faced unexpected questions, they didn't pause, they didn't look frightened. They may have slowed down a little bit, but that was simply to give them time to reflect, to construct a coherent, well-reasoned answers, which each of them managed to do. So turning now to the outcome in this moot, so we heard the appellants arguing why the appeal should be allowed, and then the respondents trying to oppose that. On the law, I find today that the appellants made out their case, that the appeal should be allowed. But on the moot, I find it was much more closely balanced, and I think by a hair's breadth that the respondents, they won the moot today. So I hope you find this instructive and useful. We'll be doing more videos like this in the coming months, and I look forward to seeing you all very soon in the workshops, which start in a few days' time. So thank you.